Consideration. Now, consideration is the element of bargain in a contract. It is an element of bargain in a contract. So that means that where parties are entering into a contract, party A and party B, what is called consideration is what Mr. A is given to Mr. B and what Mr. B is given to Mr. A. So what they are exchanging is what we call consideration. That is why consideration is also defined as some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss, responsibility given or suffer or undertaken by the other. So a consideration is the price paid by the promisor for the promise of the promisee. So it is a price paid by the promisor for the promise of the promisee. So it is the price paid by the promisor for the promise of the promisee. So that is consideration. So where people, okay, say for example, I want to sell my Bible to somebody and it's to pay me some amount of money. So what we exchange is what we call consideration. So we have some rules governing consideration. The first rule governing consideration is that one, consideration must be sufficient but does not need to be adequate. Number one, it must be sufficient but need not to be adequate. Need not to be adequate. So consideration. Now it does not really matter what people are to exchange. Take for example where A want to give his car, very valuable car, to B, let's say a Jeep, they are worth 4 million. 4 million. But Mr. A wants to sell it to Mr. B at 500,000. Okay. So Mr. B will pay 500,000 to Mr. A, while Mr. A will now give his Jeep that worth 1 million to Mr. B. Now, if they now enter into agreement, it is binding on the parties. So that is why consideration, it does not mean that what Mr. A is giving must be commensurate with what Mr. B is giving. No. What they are exchanging may not be commensurate with each other. But what matters most is that whatever they are exchanging must be of thing of value. 500,000 is a thing of value. Okay, the Jeep is a thing of value. And Mr. B that is paying 500,000 naira also is paying something of value. So court does not make contract for parties. So where they enter into an agreement and Mr. B, since there is no fraud, except where there is a fraud or where the court detect fraud, but if there is nothing like that, if Mr. B promised to pay 500,000 naira and Mr. A promised to surrender the gym, it is an agreement and it is enforceable. So consideration only need to be sufficient. It does not mean that it should be adequate. That means that it does not mean that what Mr. B is offering must be adequate, okay, to what Mr. A, the Jeep Mr. A is giving out. So it does not mean that it should be adequate. So it does not mean it should be commensurate. Okay, or what Mr. B will release to Mr. A only need to be sufficient. That's what we mean by it must be sufficient, but does not need to be adequate. Now we have instances. Okay, take for example, we have a case of Thomas versus Thomas. Where a testator told his executor to continue to pay £1 from his wife, so till the day of her death. So after the testator died, the executor now want to change and then he said that the £1 was too small for the flat the wife of the testator was using. But the court heard that that £1 was enough. Since that £1 was a sufficient consideration, and it has been agreed that the woman should be paying £1. So that was the agreement. So in that wise, what I'm trying to say is that it does not really matter. Take for example in that Thomas versus Thomas, whether that £1 was small or not. But since the agreement has been reached and that £1 was of value, so the court heard that it was a sufficient consideration, even though it was not adequate. That means that it was not commensurate with the value of the flat. So that is why it is said that consideration only need to be sufficient, but does not need to be adequate. But consideration will not be sufficient where, take for example, where in this case now, Mr. B that is to pay 500,000 naira for this very Jeep now bring 490 naira, 490,000. Okay, so he's to pay 500,000 naira. So he's not bringing 490,000 naira. So this 490,000 naira is not commensurate. So it's not a sufficient consideration because this one is contrary to the agreement reached. The agreement reached is for Mr. B to pay 500,000 naira. It's not bringing 490,000 naira. So this is not a sufficient consideration. But this also may later become sufficient if Mr. A later, maybe after some persuasion, decide to now collect this 450,000 naira. Okay, and then also agree to forgo the remaining 10,000 naira. So if that is not their new agreement, then this 490 will now be sufficient consideration. And that is what we call lesser sum. Payment of a lesser sum like this. This one is lesser to 500,000. Payment of a lesser sum is not a sufficient consideration, but may at the same time become sufficient consideration where parties agree. Okay. Then also, another thing is consideration may be executory, but must not be passed. So executed, where consideration is executed, consideration may be executory, but must not be passed. So we have these three types of consideration. Executed consideration means that party who promise, okay, who has exchanged promise has fulfilled their promise. That means that the consideration has been executed. The promises have been executed. Executory means that they have not fulfilled their promises, but they are still ready and fully prepared to fulfill their promises. So such promises is said to be executory. Then past consideration is another promise. Take for example, where these people they have agreed. One has agreed to surrender the Jeep, and the other party has agreed to pay 500,000 naira. Where Mr. B is now giving another promise of, instead of 500, is now giving another promise of 50,000. Okay, 50,000. If the Jeep is having certain facility, that new promise is what we call past consideration, and such new promise is not enforceable by the court because it's not part of the initial agreement. And also, consideration must move. That's another rule of consideration. Consideration must move from the promisee. The promisor must give promise, and the promisee must also, consideration also must move. That means that there must be an exchange of promises. Must move from the promisee. Then number 4, consideration must not be legal. Must not be legal, not illegal, must not be legal, immoral, or contrary to public policy. So that means a consideration must not be illegal, immoral, or contrary to public policy. Illegal consideration. Take for example, if Mr. A should give me money to Mr. B, and Mr. B promised to supply cocaine, so it is an illegal. That supply of cocaine is an illegal consideration. So consideration must not be, any consideration that court will recognize must not be legal and must not be immoral. Exchange of money for sex is an immoral consideration. So court will not recognize that, and court will not enforce such contract. Or anything contrary to public policy, anything at all contrary to public opinion, court will not recognize if any party is to give that as a consideration. So that's why it is said that consideration must not be legal, immoral, or contrary to public policy. Also part of public policy is that where somebody is demanding for money in order to give out contract. So demanding for bribe in order to give out contract is contrary to public policy. So such cannot be recognized by the court. Intention to create legal relation. It is also a very important number 4. Okay. Requirement for the formation of a legal contract. Intention to create legal relation means that where parties are entering into a contract, they always intend to enter into a legal relation. And we have ways by which a court will be able to understand or know that the party actually want to enter into a legal relation. And this will happen where, number 1, in their contract, it is expressly stated that they want to enter into a legal relation. Number 1. Expressly stated. Okay, that they want to enter into a legal relation. That means that where they are agreeing, they will then inform each other that we are entering into a contract, but we intend in this contract to enter into a legal relation. That means that any party in breach must be punished. So they may then, at the same time, they may say that they don't want to enter into a legal relation. That means that if they should state either orally or in written form that they don't intend to enter into a legal relation, that means that that contract is entered into in honor only. We call such in honor only. That contract is in honor only. That means that they don't intend to enter into any legal relation. So they may include in the contract that they want to enter into a legal relation, and they may not even include they may include that they want to enter into a legal relation, or they may include that they do not want to enter into a legal relation. So they may state it there either orally or in written form, okay, as they are making the contract. So with that, the court will be able to know that the parties intend to enter into a legal relation. At the same time, if contract is domestic in nature or social in nature, social as we have in Balfour versus Balfour, versus Balfour. So if contract is domestic in nature, that means a husband and wife enter into a contract. Maybe the husband promising to give his wife certain thing, and he does not do it. If the wife should now sue the husband to court, the court will not enforce the contract because it is a family contract, a domestic issue. So the court will assume that the parties do not want to enter into a legal relation because it is domestic contract, and court will not enforce it. That is what we call domestic, okay, domestic or social contract. So social contract has to do with a situation where social issue, where people agree on social issue, and so in such contract, court will not enforce it. Looking at the nature of such contract, it shows that parties do not intend to enter into a legal relation. So in the case of Balfour versus Balfour, a Briton employed in Ceylon was there with his wife. So he returned home on leave, and the wife was not able to go back with him. He promised to give her an allowance of £30 monthly until she joined him. He failed to make the payment, and the wife sued. It was said that there was no contract between the husband and the wife. So the court held that there was no contract between the husband and the wife because it was a domestic agreement. And also, number 3, where a contract is commercial in nature. So where it is commercial in nature, court will assume that parties intend to enter into a legal relation. So that is the way court may discover whether parties coming into a contract intend to enter into a legal relation or no. If it is commercial in nature, then court will assume that they intend to enter into a legal relation because it is commercial. If it is domestic, court will assume that they don't intend to enter into a legal relation. Also, it may be stated in the agreement, either in written form or in oral form, that they intend or they do not intend to enter into a legal relation.